So, in Chapter 3, Section 2, protected areas and interests within sort of the chapter topic of arrest, search, and seizure. If certain police activity is neither a search nor a seizure in the Fourth Amendment sense, then quite obviously the protections of the amendment are inapplicable. Deciding just what constitutes a search has been especially troublesome. In the leading case, and the first case in this section of Katz versus United States, holding electronic eavesdropping is governed by the Fourth Amendment, the court decided a search could occur without a physical intrusion in the constitutionally protected area, by requiring instead infringement on the justified expectation of privacy. Katz unquestionably broadened the scope of the Fourth Amendment, but the court has since taken a rather narrow view of what privacy expectations are in fact justified, as is illustrated by the next two cases, California v. Greenwood and Florida v. Riley, dealing respectively with examination of garbage and aerial surveillance. The next two cases in this section, United States v. Jones and Florida v. Jardines, dealing respectively with the use of GPS tracking devices and on-curtilage drug-sniffing dogs, both using a property interest rather than privacy approach in determining when those activities constitute a search. The meaning of Katz is also explored in United States v. White concerning the troublesome question of whether it is a search or seizure for an undercover agent secretly to record or transmit conversations he has with others. And those objecting to police search activity have sometimes relied upon constitutional protections in addition to those in the Fourth Amendment. The claim that the Fifth Amendment privilege against self-incrimination bars a search for or seizure of private papers was rejected by Anderson v. Maryland in 1976. Distinguishing the situation discussed in Chapter 8, the court in Anderson concluded that although the Fifth Amendment may protect an individual from complying with a subpoena for the protection of his personal records and his possession, because the very act of production may constitute a compulsory authentication of incriminating information, a seizure of the same materials by law enforcement officers differs in a crucial respect. The individual against whom the search is directed is not required to aid in the discovery, production, or authentication of incriminating evidence. The claim that the First Amendment freedom of the press is violated by the search of the office of the news gathering organization is considered in Zurcher v. Stanford Daily, the final case in this section. So for Katz in the United States, page 92, tried in 1967, Justice Seward delivers the opinion of the court. The petitioner was convicted of transmitting wagering information by telephone from Los Angeles to Miami and Boston in violation of the federal statutes. At trial, the government was permitted, over the petitioner's objection, to introduce evidence of the petitioner's end of telephone conversations overheard by FBI agents who had attached an electronic listening and recording device to an outside of the telephone booth from which he had placed his calls. In affirming his conviction, the Court of Appeals rejected the contention that recordings had been obtained in the violation of the Fourth Amendment because there was no physical entrance into the area occupied by the petitioner. We granted certiorari in order to consider the constitutional questions thus presented. The petitioner has phrased those questions as follows. A, whether the public telephone booth is a constitutionally protected area so that the evidence obtained by attaching an electronic listening or recording device to the top of such a booth is obtained in violation of the right to privacy of the user of the booth. And B, whether physical penetration of a constitutionally protected area is necessary for search and seizure can be said to be violative of the Fourth Amendment to the United States Constitution. So what I wrote for the issue is, if there is no physical entrance into an area occupied by a petitioner, is it a search and seizure further inconsistent with the Fourth Amendment to collect data? Well, I could probably leave that part off, but this is actually eavesdropping at public phone booth. So, we decline to adopt this formulation of the issues. In the first place, the correct solution of the Fourth Amendment problem is not necessarily promoted by incantation of the phrase constitutionally protected area. Secondly, the Fourth Amendment cannot be translated into a general constitutional right to privacy. The amendment protects individual privacy against certain kinds of governmental intrusion, but its protections go further and often have nothing to do with privacy at all. Other provisions of the Constitution protect personal privacy from other forms of governmental invasion, but the protection of a person's general right to privacy, his right to be let alone by other people, is like the protection of his property and of his very life, left largely to the law of the individual states. Because of the misleading way the issues have been formulated, the parties have attach great significance to the characterization of phone booths from which the petitioner places calls. Petitioner has strenuously argued that the booth was a constitutionally protected area. The government has maintained with equal vigor that it was not. But this effort to decide whether or not a given area viewed in the abstract as constitutionally protected deflects attention from the problem presented by this case. For the Fourth Amendment protects people, not places. What a person knowingly exposes to the public, even if in his own home and office, is not a subject of Fourth Amendment protection. But what he seeks to preserve is private, even in an area accessible to the public, but may be constitutionally protected. So, there's no necessarily a right to privacy under the Fourth, and there's also no such thing as a constitutionally protected area. But, maybe consider an office, which I think is beyond the court to answer that question. But anyhow, the government stresses the fact, due to justiciability doctrines. So the government stresses the fact that the telephone booth from which the petitioner made his calls was constructed partly of glass so that he was visible after he entered as he would have been if he had remained outside. But what he sought to exclude when he entered the booth was not the intruding eye, it was the uninvited ear. He did not shed his right to do so simply because he made his calls from a place where he might be seen, no less than an individual in business office, in a friend's apartment, in a taxi cab. A person in a telephone booth may rely upon the protection of the Fourth Amendment. One who occupies it shuts the door behind him and pays the toll that permits him to place one call, is surely entitled to assume that the words he utters into the mouthpiece will not be broadcast to the world. To read the Constitution more narrowly is to ignore the vital role that the public telephone has come to play in private communication. The government contends, however, that the activities of its agents should not be tested by Fourth Amendment requirements for the surveillance techniques they employed involved no physical penetration of the telephone booth to the petitioner places calls. Although a closely divided court opposed in Olmstead versus U.S. states that surveillance without any trespass and without the seizure of any material object fell outside the ambit of the Constitution. We have since departed from the narrow view on which that decision rested. Indeed, we have expressly held that the Fourth Amendment governs not only the seizure of tangible items, but extends as well to the recording of oral statements overheard without any technical trespass under local property law. Once as much is acknowledged, and once it is recognized that the Fourth Amendment protects people and not simply areas against unreasonable searches and seizures, it becomes clear that the reach of the amendment cannot turn upon the presence or absence of physical intrusion into any given enclosure. We conclude that the underpinnings of Olmstead have been so eroded by our subsequent decisions that the trespass doctrine, were enunciated, can no longer be regarded as controlling. The government's activities in electronically listening to and recording the petitioner's words violated the privacy upon which he justifiably relied while using the telephone booth, and thus constituted a search and seizure within the meaning of the Fourth Amendment. The fact that the electronic device employed to achieve that end did not happen to penetrate the wall of the booth and can have no constitutional significance. The question remaining for the decision then is whether the search and seizure conducted in this case complied with the constitutional standards. In that regard, the government's position is that its agents acted in an entirely defensible manner. They did not begin their electronic surveillance until an investigation of the petitioner's activities had established a strong probability that he was using the telephone in question to transmit gambling information to persons in other states in violation of the law. So does that say, okay, probability, strong probability? Moreover, the surveillance was limited both in scope and in duration to the specific purpose of establishing the context of the petitioner's unlawful telephone communication. The agents confined their surveillance to the brief periods during which he used a telephone booth, and they took great care to overhear only the conversations of the petitioner himself. Accepting this account of the government's actions as accurate is clear that the surveillance was so narrowly construed that the duly authorized magistrate properly notified that the search for such investigation specifically informed of the basis on which it was to proceed, and clearly apprised of the precise intrusion in which informed of the basis on which it was to proceed, and clearly apprised of the precise intrusion it would entail, could constitutionally have authorized with specific safeguards the very limited search and seizure that the government asserts the fact took place. The government urges the creation of new exception. To cover this case, it argues that surveillance of a telephone booth should be exempted from the usual requirement of advance authorization by a magistrate upon showing a probable cause. We cannot agree. Omission of such authorization bypasses the safeguards provided by the objective predetermination of probable cause and constitutes instead the far less reliable procedure of an after the event justification for the search, too likely to be subtly influenced by the familiar shortcomings of hindsight judgment, and bypassing a neutral predetermination of the scope of a search leaves individuals secure from Fourth Amendment violations only in the discretion of the police. These considerations do not vanish when the search in question is transferred from the setting of a home, an office, or a hotel room, or at the telephone booth. Whether a man he is entitled to know that he will remain free from unreasonable searches and seizures. The government agents are here ignored. The procedure of antecedent jurisdictions that is central to the Florida Amendment procedure that we hold to be constitutional of the kind of electronic surveillance involved in the case. Judgment reversed. So Harlan concurs, Black dissents, and that's it for follow-on decisions. So, as the court opinion states, the Fourth Amendment protects people, not places. The question, however, is what protection it affords to those people. So, understanding the rule that has emerged from prior decisions is that there is a twofold requirement. First, that a person have exhibited an actual subjective expectation of privacy, and second, that the expectation be one that society is prepared to recognize as reasonable. Thus, a man's home is, for the most purposes, a place where he expects privacy, but objects, invites, or statements that he exposes to the plain view of outsiders are not protected because no intention to keep him to himself has been exhibited. On the other hand, conversations in the open would not be protected against being overheard, for the expectation of privacy under the circumstances to be unreasonable. So they reversed this judgment. It is central. The procedure of antecedent justification that is central to the Fourth Amendment procedure that we hold to be a constitutional precondition of the kind of electronic survey involved in the case. Okay. So, where was I? Black dissented. Tapping telephone wires, of course, was an unknown possibility at the time the Fourth Amendment was adopted. But eavesdropping and wiretapping is nothing more than eavesdropping by telephone, was an ancient practice which at common law was condemned as a nuisance. In those days, the eavesdropper listened by naked ear under the eaves of houses or their windows or beyond their walls. Seeking out private discourse, there can be no doubt that the framers were aware of this practice, and if they had desired to outlaw or resist the use of obtained by eavesdropping, I believe that they would have used the appropriate language to do so in the Fourth Amendment. They certainly would have not have left such a task to the ingenuity of language-stretching judges. By clever and juggling, the court finds it plausible to argue that language aimed specifically in searches and seizures of things that can be searched and seized may, to protect the privacy, be applied to eavesdrop evidence, to conversations that have neither have. I lost my spot. The court has made the Fourth Amendment its vehicle for holding an all laws violative of the Constitution which offend the court's broadcast concept of privacy. The Fourth Amendment protects privacy only to the extent that it prohibits unreasonable searches and seizures of persons' houses, papers, or effects. No general right is created by the amendment so as to give this court an unlimited power to hold unconstitutional everything which affects privacy. Certainly, the framers well acquainted as they were, the excesses of temporary power, temporary. Okay, not really all that important. So I'm just going to close down this reading because that is essentially like the very end.